2018. And ma'am, your name for the record, please.
Olivia Lucille Braskage.
Okay, today is the date scheduled for
As
sentencing.
sentencing begins, the courtroom reviews the defendant's plea, disorderly conduct, and careless driving. What initially started as an OE investigation has now shifted into a reduced charge, an outcome the judge notes was highly favorable, given the original allegations and the potential consequences that could have followed.
Scheduled for sentencing in this matter on your client's plea to disorderly conduct and careless driving. And counsel?
This clarification, Harris was dismissed at that time. It's just on,
I'm sorry. No, I'm showing responsible to count two, careless.
oh,
Yes, I mean, technically, it's fines and costs only, so there's not any sentencing to be had on that, but your client did plead responsible to careless driving as well.
very good. We have gone over the pre-sentence investigation report and recommendations. There are no corrections, deletions, additions to place on a record before Your Honor, and just like to address some of the recommendations, if we may.
Okay,
Recommendation is for a 9-month probation term. I don't know if that's a required minimum period, but we would ask, because we, frankly, the chemical awareness program and anything that is required of her could be completed 6 months if we, I don't consider a 6-month term. Secondly, the workforce. Client is a nurse operating, well, she's a surgical nurse, and she has pretty long hours. She works 8 hours or 12-hour days, and they vary week to week. She has to work Saturdays frequently, and those are 12-hour days, but asks for some more flexibility by being able to have her fulfill her probation requirements by doing volunteer community service in lieu of the corpus work program. And other than that, time to pay would be requested depending on the amount of fines and costs, but she can probably pay $200 today or tomorrow actually would be an effective date if that's possible.
okay, well, here's, first of all, is Eric Bells present? No. So counsel, this is a reissue, it appears, or a recharge, an amended charge. Because originally your client, I believe, was charged with operating while intoxicated, was she not? Right. So then there is a resolution reached between counsel that there was going to be, that matter was going to be dismissed. A new charge of disorderly person and careless driving were going to be put forth. And that
last appearance.
The judge reminds everyone that reduced charges still carry responsibility. Despite long work hours and personal obligations, the court emphasizes accountability and rejects the request to shorten probation. The message is clear. The leniency already granted should not be taken lightly.
Last appearance was a plea when the plea was placed on the record, a no contest plea to the charges.
correct, I understand that. But my point is this, your client was a .231. A .231. She had a parked car. Ma'am, if you're chewing gum, please grab the tissue from underneath the podium and get rid of it. Your client was a .231. She had a parked car. And I don't recall if there were evidentiary issues or what was the reason why this that the prosecutor dismissed the original charge and then this was the resolution. I don't recall specifically. I think it may have been some evidentiary issues. However, your client has been significantly fortunate in how this entirety has played out. She doesn't have any licensing sanctions that are going to be occurring to her or to her nursing license or otherwise. So to now come in here, ask this court instead of 9 months for 6 months, which if she's done in 3 months, she's done in 3 months, right? Because of early discharge. And that she works long hours and that she needs a more flexible condition other than workforce, the court's not inclined to do that, counsel. Your client is here because of her actions, because of her choices to get in the car that day. So the court doesn't want your client to rush through the conditions this court's going to put forth. And this court quite honestly finds that 9 months is actually on the low end. However, and I don't know if when Ms. Shine reviewed this, if she noticed or if she realized that this was a recharge. In counsel, as to your question, you're not sure if that's a required amount of time. I don't have this court doesn't have a required anything for cases. The court takes each case individually as it is. And the court, after hearing from counsel, reviewing the report, the recommendation, the court does find there's reasonable grounds to depart from MCL 769.5. The court also finds the following sentence being the best purchase of justice to be reasonable and proportionate to the seriousness of the matter, taking into account the circumstances surrounding Ms. Braskich.
Your Honor, the only reason I asked for some flexibility, I just didn't want to set her up for failure with regard to.
With the conditions laid out, probation becomes the structured path forward. Programs, testing, and community service are ordered not as punishment alone, but as tools to prevent repeat behavior. The court stresses rehabilitation, education, and personal responsibility as the guiding goals for the months ahead.
Regard to knowing her schedule and not sure how flexible, or I know it's generally less flexible to go through the work program than to be able to initiate and schedule community service.
No, I can appreciate that, but she can work it around her schedule. And counsel, your client also gets the benefit of the 771.1. So your client has a really good deal that she was able to obtain by way of her counsel. So the court's going to order 12 months probation. You're eligible for early discharge. I'll go over that shortly. You're also eligible under 771.1 status. You are not to violate any criminal law of any of government. You're not to leave the state without the consent of this court. You are to report truthfully to your probation officer as often as your probation officer may require. In person, writing, or virtually, you're to notify your probation officer immediately of any change in address or employment status. You are not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. You are also to participate in the chemical awareness program. The rehabilitative goal for that condition is to further educate you about drug and alcohol use so you can make better informed decisions in the future, hopefully preventing this matter from happening again. You are to participate in the MAD Victim Impact Panel. The rehabilitative goal for that condition is so you can further understand the consequences of operating while under the influence and hopefully take something from that so that you're not doing this again. The court's going to also order 5 days on the court workforce. The rehabilitative goal for that condition is to help you further develop life skills and give back to the community. Do you have any questions regarding those conditions?
No.
The court's going to order a $500 fine, $100 screening assessment fee, $600 supervision oversight fee. That's $50 a month at 12 months. And since you're eligible for early discharge, up to half of that could be waived. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, workforce $200. That's 5 days at $40 a day, and then $75 for the chemical awareness program. $1,900 is the total. You said you have $200 to pay today?
Yes.
All right, so then on your $1,700 balance, I'll have you work that out through probation. As I did indicate, you're eligible for early discharge as long as all the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations, and all monies have been either paid in full or you've made a good faith effort toward making full payment. Do you have any questions?
No, Your Honor.
All right, let me just confirm that this is the cost. Yes, that was, I just want to make sure my addition was correct. Okay, stop at probation. Somebody will be with you shortly.
Thank you.
Thank you.
Thank you. Go off the record for a moment. There's the line custody. What?
That's all actually.
Yes. Oh.
Oh.
Good morning, Wayne County Jail.
Good morning, Judge DeSanto. Happy Thursday to you. We got one more to go, Your Honor.
One more to go.
One more. I have 4 for you scheduled today. 2 of
Okay.
the bodies I have. Yes, ma'am. I have 2 of the bodies here already. The first one is en route, Mr. Henry Johnson.
Okay.
The second one is here, Ms. Marlene Myers.
Okay.
Third individual is here, Zaire Robinson.
Okay.
The last one is a 1 p.m. schedule. If you want this individual earlier, we can get her. Her name is Nicole Mate.
Okay. I don't know if her attorney will be here until 1 o'clock, so I appreciate that, but we may have to wait till 1 o'clock for that for her. Do you also have? Oh, I'm sorry. Just so you know, I believe that on Mr. Robinson and Miss Myers, the assigned counsel division we did not receive an appointment. So the assigned counsel division was working on getting an attorney appointed for both of those individuals.
Okay.
So if you can put Mr. Johnson on, then we can have him speak with his attorney in a breakout room.
Okay. As soon as that body get here, Your Honor, that will be the individual in the seat.
Okay, perfect. Thank you.
Thank you, Your Honor.
All right. And then we are on the record in the matter of the state of Michigan versus Dawn Olson, 251127.
Your Honor, Edward Zelenak for the defendant, Ms. Olson, please give your name to the judge. Speak clearly, audibly.
Dawn Margaret Olson.
Judge,
Okay.
there's a
So
minor problem here. I
hold on one moment. Hold on 1 second. Terry, can you hand me the greenback on Miss Olson, please? Brian had taken it out of the file because
I think it went back to probation.
no, it was supposed to just stay out for me to look at. Not there? Okay.
I have to go get it.
Well, that's okay. We have to wait till somebody comes in. Okay, what's that, Mr. Zelnick? Sorry.
Oh, I actually, that would be like a big one, Judge. Ms. Olson was found not suitable for candidacy for the sobriety court in the 23rd District Court. And the reason is simply that she was under prescription narcotics driving at the time. She's off the drugs now. She's clean and indicated she would not fit their parameters of having a problem. And she agreed she was taking it for pain. And that's
Well, if I recall in reviewing the file, counsel, your client also indicated that she does not feel as though she was operating while she was under the influence. So for a number of reasons, your client was not deemed eligible based upon her responses and otherwise.
I was going to tell you that. That's
Okay, sorry.
No, I know. And I discussed it with Ms. Olson. And when you rely on
As the
prescription.
docket moves on, new defendants appear, each with complications of their own. Some face failures to pay, others struggle with health, addiction, or unresolved charges. For the judge, these moments highlight a recurring challenge: balancing fairness, public safety, and the individual circumstances of every person who steps before the bench.
Rely on prescriptions and you combine them and drive. It says right on the label, not to operate equipment, or at least we used to when I grew up. And I think I spoke with Mohammed, the assistant prosecuting attorney, and he suggested the letter applied in another court. And we may be just pounding sand on that. That may not be worth doing, Your Honor, because she's never going to fit any parameter of a problem unless she comes to grips that she can't take prescription drugs. Her other offenses were alcohol. And I don't want to burden this court unduly. And I went to look for Sergeant O'Gorn to see what he thought, because you may recall that it took months to get the warrant back. They kept denying the warrant. He'd send down more evidence. They finally came through, and I see why, because they may look at it as a borderline case. I don't certainly want to hold an exam. would court allow us to explore the possibility that if we enter a plea as charged here and schedule for sentence, if there's a sentence agreement downtown, we can then resolve the case. I think that putting her in a sobriety court burdens both court unfairly and Miss Olson, because you have to buy into what the dicta is. And I'm not sure she's ready to do that because it was prescription drugs, Judge.
Well, here's the issue. The plea that this court took was based on your client participating in a treatment court.
That's true.
So we're here, it's set back up for a probable cause conference to see whether or not the plea is going to still stand as put forth or not. Because the plea, after much deliberation with Mr. Bresnahan, presumably, dismissed the OWI third and allowed your client to plead to a misdemeanor for her participation in treatment court. And if she's not eligible, what's that?
I don't think that's going to happen.
Okay, well then you and Mr. Mohammed need to determine what's going to happen. I mean, I don't think if it doesn't seem logical to adjourn it for 2 weeks to see if your client would be eligible under the 25th District Court, because your client doesn't think that this offense is anything related to that.
Judge, I agree with you. I think Miss Olson agrees, and Mr. Mohammed suggested we try this to see if she could get into another court, but I think we're just pushing the problem to another court. We'll be back here at the same issue. So, subject to your approval, Your Honor, we would either ask for another PCC date or an exam date so I can discuss a waiver, or maybe getting a plea to the felony here and scheduling a sentence downtown if I can work out a sentence. It's up to you. I know that we're wasting the court's time by trying to get her into a treatment court. Essentially, that's what in a lot of words, I should have just said in one sentence. We're wasting the court's time.
Well, I mean, I'm here, not wasting my time at all, but well,
We're burdening the court.
then I'll have you go back and talk to Mr. Mohammed, and if you're setting it for an exam, then let him know that, and then we can pick a date.
Can you pick a date now? And if it's a problem, we'll change it. There's no reason to see him. We don't want to waste the court's time.
I need him to redo the sheet. Yeah, you have to see him. Yeah, that's okay.
I don't want to come back with another sobriety court note, Judge. It's not fair to the court.
No, I understand that, but I gotta just so you know, we're looking at probably December 4th.
That's the date that we had discussed, Your Honor.
So, okay, so if you want to have a chat with Mr. Mohammed and just figure that out.
We'll be right back.
Thank you. All right, we are recalling the matter of the city of the state of Michigan versus Dawn Olson, 251127.
So that for the defendant, Your Honor.
All right, thank you, ma'am. Your name for the record, please.
Don Margaret Olson.
Judge, we would ask the court to allow us to proceed to an exam. I know the term itself shocks the court. It comes from my mouth. I don't believe we'll hold an exam, but I want to talk to Sergeant Oborn to find out what preponderance of evidence they have. If we're going to waive it, I'll let the court know in plenty of time so they don't bring witnesses in. And parenthetically, Your Honor, I can't sit with a client who's visiting with a sobriety court and tell them how to answer questions. I believe she answered them honestly, and I believe she doesn't think it's a problem. She's on prescription drugs, and there's nothing I can do to change that. And she would be wasting the court's time, in my opinion, to be in a 2-year program when it's doing what you've done now, which is you're not taking Norco anymore.
Correct, I'm not.
And counsel, I don't disagree with you. I just simply the plea was what it was. And so since your client's not eligible for treatment court, then the entire plea has to be reworked.
That I'm straining the court along.
No, not at all. Not at all. And
That's what they
your
have-
client needs to be honest when she's interviewing for her eligibility in a treatment court. Or otherwise, there's not a purpose for that, right?
Understand, and I certainly wouldn't want to burden this court or any other court. And I'm convinced this is the right move. And if the exam's waived, they got those high-priced judges downtown to deal with this problem. We'll take care of it there, Judge.
Okay, and just so you know, nothing shocks me anymore that comes out of anybody's mouth. So
Even when I asked for an exam.
yes.
So you're going to waive all those rules. We're going to have an exam 3 weeks from today. All right. What time, Judge?
My boss is going to tell me that in just one moment.
We're not going to need any lab techs or anything. So
Okay.
we'll make it easy.
At 11.
Very well. That's what I guess. Thank you, Judge.
All right, and then witness exhibit list by December 1st, okay?
Yes,
Bond and conditions are continued.
Your Honor, thank you. It's nice to be here today.
Thank you very much. Have a good day. And we are on the record in the matter of the state of Michigan versus William Griggs II, 23488.
Ready, Your Honor. Morning again, Your Honor. Neil LeBlanc here on behalf of William Griggs. Please get your name.
William Jeffrey Griggs II.
Thank you.
All right, and good morning. Today is the date scheduled for a show cause in this matter because you also have not continued to make your payments after your discharge from probation, sir. Allie, what does it show the balance is on this one?
1,500.